All right, good morning, and thank you for being here today. This is our final installment of the ESELA session for the 22-23 school year. Today's session will be on conflict management and conflict resolution. We're excited to have Laura Anthony here again to join us from Bricker and Eckler. If you are needing ASL and interpretation, the names are in the list as ASL interpreter. Nick and Alicia are so kind to help us out today with that. We will also turn on the closed captioning for those that need it. Looking forward to next year, we are still working out logistics. We hope to continue this series in our partnership with Bricker and Eckler. As you guys know, most of you know by now, I'm sure word's traveled, the new operating standards are set to release in July. With that around our ESELA programming next year, there should be some changes, some new discussions, things like that. So we are looking to continue that series. What that looks like right now, we're not totally sure, but just keep an eye out. Hopefully, by late spring this year, we'll have a better idea of what that's going to look like. We are also getting wind that there are going to be some changes to the IEP and ETR documents, potentially with the new operating standards. So we just heard kind of some rumblings about that yesterday, but haven't had anything definitive to share with you today. We just wanted to let you know to keep that on the horizon moving forward. If you have any questions, please put them in the chat box. Aaron Curtis, one of my colleagues from State Support Team 11, will help relay those messages to Laura, and we will go ahead and get started for the day. It's all yours, Laura.
All right, well, welcome everybody. Thank you guys for hanging in for the entire series. We end with conflict management because honestly, this is the time of year that there's a lot of conflict. We see certainly a lot of uptick in our practice, and my understanding is that from the state, they have the same thing. So Stephen, are you going to share the screen with the presentation? Okay, there it goes. Awesome. All right, so what we're going to do today, we're really going to talk about some things that typically get people agitated. We're going to talk about the top 10 special ed issues that get people agitated and can result in costly conflict. We're going to talk about some conflict resolution strategies. So if you have not been involved as a decision maker in your school district for various types of conflict, we're going to give you some tips and give you a preview of the things that could come their way and come your way, excuse me. And then we're going to talk about how to resolve them. We will take a break during the during our time together. Probably, let's see, it's 9. Let's see if there's a natural break point, and you can refill your coffee, whatever else it is you're going to be doing during the break, answer emails, all of the things. Because of course you're not going to be looking at emails during this presentation. Just kidding, I get it. So hopefully you are not sticking your head in the sand and answering emails and saying, conflict's never going to happen in my district. We do everything right, and we will never have a complaint or a due process action or a complaint filed with the U.S. Department of Education. Nobody's ever going to come to our board meetings and make some public comment. Nobody's going to ever take to social media and make some comments. Nobody's ever going to organize a parent group. Nobody's ever going to call the media to, be there during my child's IEP team meeting. That stuff's never going to happen to us. If that is true, please sign off now. Go ahead, sign off. But my suggestion to you is that is not going to happen. Let me just give you some statistics. I have a team of 30 education professionals who full-time work with schools across the state of Ohio. We need 30 people because there's a lot of conflict. There's a lot of times when schools get complaints or lawsuits or due process hearing requests or requests for mediation, requests for any other type of conflict resolution process. And so we have a lot of lawyers working on this because there's a lot of conflict. If there wasn't any conflict, I would be out of a job. Not to say that I like conflict, but it just is a natural part of special education. So I want you guys to think about, hold on, I'm going to get a drink. I want you to think about how many of you have children. Okay. How hard would you fight for your child? That's the kind of conflict that happens in, excuse me, special education. And so the conflict isn't the garden variety, it's about people's kids. So it can be very emotional. It on both sides, it can be very emotional for parents, it can be very emotional for school team members, because newsflash, most educators did not get into the business of education for the money or for the glory of it or for the accolades or for the, they got into it because they want to help kids. They want to educate kids. And so people are typically in it for the right reasons. And so when there is conflict, when people are told that they're not doing a good job or there is a disagreement about something, that becomes very personal, particularly for educators and, and for parents, obviously. So conflict management and conflict resolution involve many elements, some of which, maybe a very small part of which, is the legal piece of it. There is a lot of law that goes on, but a lot of it is emotional management, and a lot of it is communication skills, and a lot of it is understanding people's needs and their wants and what they can live with. And so my hope is today that framing this as a managing conflict and resolving conflict, that's our scope today. Avoiding conflict just is not something that I'm going to put out there as a talking point. Now, I'm going to talk about those things that typically generate conflict, but those are things that are not going to be topics that you can avoid. All right, so we're going to move into our first part of the session, which is the top 10 special ed issues that can result in what I will call expensive professional development, okay? Expensive costs for school district. The first one is not taking appropriate action in response to concerns about bullying and disability harassment. Why do I put this up there? This first point is, you probably heard when Melissa was giving the presentation on Section 504 that students with disabilities have protections under Section 504. And those protections exist so that students do not experience, and their parents who are advocating on their behalf, do not experience discrimination and harassment based on the protected class of disability status. So what could that look like? That could look like things that we talked about in our 504 session: disciplining a student for behavior that is caused by their disability. Or it could look like others in the school, kids, staff, harassing the student based on their disability status. So for example, if a student who has, a food allergy, let's say a peanut allergy, and kids are throwing Reese's Pieces at the student in the middle of the cafeteria because they're mad that they couldn't have the Halloween party because they got a kid with an allergy, that could be considered harassment based on disability status. And these things can be costly, because anytime that you have litigation or complaints based on a protected class, which is disability status, those can be civil rights actions. Those can be actions that are filed in federal court and can result in large damages awards. And sometimes disability harassment, disability discrimination can be not only costly in terms of the cost of litigating, but it also can be costly in terms of what happened. Many, many cases out there where students with, in protected class, students who are disabled, students who maybe have emotional disturbance, students who identify as within the community of LGBT, they suffer harassment in a disproportionate way than other members of your school community. And sometimes there are suicides based on harassment and discrimination based on, because of their disability. There's also some cases out there where students with disabilities, like students with severe allergies, have died because they were bullied or harassed because of their disability. There's a case in the United Kingdom where a student with a milk allergy, other kids put a piece of cheese on the student, on their back, put the piece of cheese down their shirt. Student had an anaphylactic reaction and died. So if there is something that looks like, sounds like, seems like harassment based on a protected class of disability status, you need to know that building administrators don't take care of that. It's likely going to be many of you in the audience who are serving as the district's civil rights coordinator or the district's 504 coordinator. So you need to make sure that your building administration knows that if somebody says, I was treated differently because of my disability status, they were making fun of me, I was excluded from this, that is not something that they should handle. That is something that should go to your district civil rights coordinator. And if the school doesn't handle it correctly, meaning pursuant to your district's policy, then there could be a costly dispute. Second one is failing to understand your obligations concerning non-academic and extracurricular activities. So in 2013, the U.S. Department of Education Office for Civil Rights issued guidance in the form of a Dear Colleague letter. And that really explained the obligations that schools have for making athletic opportunities available for students with disabilities. And so this was based on, and I know this is 10 years ago, but it is very important for schools to understand what obligations they have for students with disabilities participating. They're required to have an equal opportunity to participate in non-academic and extracurricular activities. And so those are things that are going to be included in the, athletics, things that you would think about in terms of, clubs and, they're school sponsored, the play, the pep rally, all of the things, right? And so if students with disabilities require some support, the IEP has to contain a statement of the supports and services that are going to be provided to the student in order to enable them to have an equal opportunity to participate. So that is a required element of all IEP team meetings, that you're having that conversation. But keep in mind that requirement exists for students who are protected under Section 504. So keep in mind, I keep saying that these students are protected. They might not have a 504 plan because you're not giving them any affirmative services. However, they are protected from discrimination, meaning, you can't kick somebody, you can't not allow somebody to be in the high school play if in kindergarten they had an IEP with speech therapy, right? I don't want anybody with articulation issues not being able to deliver their monologue, right? So that could be discrimination. Similarly, if somebody is hearing impaired and they require interpreter services in order to participate in an extracurricular activity, that's going to be a conversation that needs to happen at the IEP team meeting. So that Dear Colleague letter is really helpful, and something that if your coaches, your athletic director, the director of the school play, the advisor of the chess club, the facilitator of the French Society, if those individuals don't have good visibility on the requirements, that is a good resource for you to provide to them. And again, it does talk about athletics, but the concepts extend beyond that. All right, on our next slide, I think the next one is section 504, perhaps. Oh, no, not accessing experts. So this is all about getting a second opinion. So as school districts really should develop internal expertise on particular topics. Do you have somebody in your district who has an expertise in behavior management? Do you have somebody in your district who has a particular training or expertise in reading intervention? If you don't, and you have a case in which there is a disagreement about the appropriate strategies for behavior management or the appropriate strategies for improving a student's decoding skills, this is where you should get external support. Lots of different areas of need. You might need something in the area of communication. You might need something in the area of addressing a student's needs of a very low incidence disability, Prader-Willi syndrome, something that is very, doesn't come up very often. But if you have that, getting a second opinion is really helpful, because when things get into conflict, you can bet that the student's family will get an expert, and that expert will tell you what you're not doing correctly. So it's helpful to go outside of your district and be proactive and coordinate with outside experts, including those who are working with the student. So if you have a student who is getting a particular type of therapy, it's always a good idea when the parent brings that information to the IEP team to be open and say, we'd love to consult with that person. We'd love to get information, get records, maybe even conduct an observation when they're getting that therapy, so that you can, and you'd say, we'd love to, if there's good strategies, we'd love to implement those strategies in the school environment, or even if there's different rates of progress in each, somebody's doing private reading intervention and they're doing, a different scope and sequence of the methodology that you're using. That's important information to know. So coordinating with those individuals, and then don't wait until there's a legal challenge. There's many avenues to explore for where you get these experts. Your SSTs, your ESCs can be really helpful in pointing you in the right direction, as can your affinity groups, that you belong to, that can point you in the right direction. We often provide connections to experts, but it's really helpful to have that in place before there's ever a challenge. But if there is a challenge, then you're probably going to need somebody, if it's just to expand your perception. And then also, when somebody's requesting an independent evaluation at district expense, don't poo-poo that. I mean, that's good to have that information up front. You probably remember from our procedural safeguards talk that independent evaluations, you have two responses. When there's a request for an independent evaluation, you can say, yes, here is the criteria for the district, or you can file due process and say, we're not going to do it. And it's pretty rare that the school will file a due process to say they're not going to provide an independent evaluation, because it's usually less costly to just do it. And I would submit to you that it's also, you want to have visibility on what other experts are saying. I don't like to get surprised when I'm having a school psychologist take the stand, like 5 days earlier, I just got this report from the parents expert. No, I want to know way before that. I want to know so that we can have an IEP team meeting and talk about it as a team. All right. Our next point is another top costly mistake is mistakes that arise from child find blunders. So, when an out of sight, out of mind, I don't hear anything, things sound good, haven't heard, not a good strategy for dispute prevention, because a lot of times the things that are quiet are really just brewing for dispute. So when you say, well, we're not considering the eligibility of the student when they come to school. Let's say it's a kid who experiences truancy. Well, when they come to school, they do fine. Well, that's a problem, because why are they not coming to school? Is it related to a disability? Is it related to a health condition? Is it related to the parents' dissatisfaction with the district's program? So, not those out of sight, out of mind kids, those can create big issues. And the reason that child find is a costly one is because you can never defend what you would have done. So for example, if you didn't know, or if you weren't paying attention to the signs that a student was suffering from some mental health issue and they're not coming to school, maybe they're hospitalized, whatever, and you just say, send the truancy officer, and the parent then identifies a residential treatment facility in another state and comes back and says, hey, I want you to pay for this residential treatment facility. You're not going to be able to defend anything, because you don't have an evaluation on the table, you don't have an IEP on the table if the student qualified. So it becomes difficult to defend. And then if that residential treatment facility is 6 figures a year, it can be costly. The other thing that is costly is when you fail to consider the disability needs of those students who are achieving academically, but they are struggling in some other element of their educational performance, like their social emotional status, their communication status, their ability to interact with peers. So those achievers should trigger some child find responsibilities if they are having needs in other areas. All right, next one is 504. I mentioned that earlier, just to know where it came in the list. Don't forget students with health conditions that don't require special education. There may be students who, they have diabetes and their diabetes is completely controlled by medication. They don't require any type of service or support from the district. However, if they try out for the basketball team and somebody says, I don't want anybody who's ever had a diabetes diagnosis, I don't know why they would say that, but then that's discrimination. So students may not require any type of accommodation. They may not require any type of plan. However, they may be protected under Section 504. They might be protected from discrimination. We talked about that earlier, bullying, things like that. And those students require you to consider their child find under Section 504 and consider what protections they have. And you would be giving them their notice of procedural safeguards under Section 504. So they know if they have a concern, they can, deal with that concern under the district's grievance procedures. All right, our next issue that causes costly disputes is when schools make a decision. I think I'm on the next slide. I may be getting ahead of myself. Yep, making a decision based on anything other than the needs of the child. And this is your classic predetermination. So if the district says, we don't have, or we don't believe in this particular educational methodology, that's making a decision not based on the needs of the child, but based on some administrative decision that is some edict somewhere. So that's predetermining. Or if you say all kids in our district get 30 minutes, all kids who are eligible for speech get 30 minutes of speech once a week. That's making it so that we can schedule everybody in. We only have a speech therapist who's there on Tuesdays. And in order to get everybody in at this building on a Tuesday, we have to limit it to 30 minutes. Well, that's predetermination. Predetermination is not preparing for a meeting. So preparation is not predetermination. It is, predetermination is when you've already decided. And the reason that predetermination can be so costly is because it is evidence that the parent wasn't a meaningful participant in the conversation, in the decision-making. So you have to ensure that you are having the parent participate, that you're not making decisions outside that process, and that you document that the parent participated. A lot of times in some of the IEP software programs that we see, there won't be the ability to save a draft. So the draft IEP is developed, you send that to the parent, you come to the meeting and the parent provides a whole bunch of things to contribute to the IEP conversation, and you update that IEP, and then it becomes the final IEP. Well, I love to see the difference and a comparison of the initial draft to the final draft, because most of the time that documents the contributions of the parent. So if you don't have a way to keep that electronically, a draft of the IEP, keep a hard copy. The other thing that you want to do is to consider every request. So even those requests that are super crazy, that you might think are super crazy, or things that can't possibly be expected to provide, you have to consider those. And so you can't foreclose the conversation until you can't close the conversation until you get to an IEP team. So when I say respond appropriately on this slide, you have to communicate clearly that all decisions are based on a team's conversation, a team's consideration of the information presented and the determination of what a student needs for the provision of FAPE. So your perfect response has to include 5 elements. So number 1, it's the team. It's not me. If you're the principal, I don't make that decision. Number 2, that you're going to have a meeting, right? And you're going to look at data, so the information in front of the team, and then you're going to look at the need of the student, not what's nice, but what is necessary for the provision of a free and appropriate public education. So anytime there's a request, you have to respond like that. If somebody's asking for private anything, private therapy, private placement, to work with a private consultant, make sure that is considered by the team, right? Schedule an IEP team meeting so the team can consider that request. And don't just stop there. Gather information about that request. Oh, you want this school to implement Hooked on Phonics? How did you hear about that? Oh, you watched an infomercial in the middle of the night. Okay, have you ordered any books? Have your student been participating in that program? If you're working with a tutor, can we have get the tutor's information and talk to the tutor? Do you have any data to show the progress? We'd love to see all that, so that we can make a good decision. The team can make a good decision. So ask all of those questions before you sit down with the team to make a decision as to whether or not the student requires private services for the provision of FAPE. Our next one, something I touched on earlier, is ignoring mental health and behavioral needs. Just because the student is getting good grades doesn't mean that there are no need for specialized instruction. The student might require specialized instruction in the area of emotional support, communication support, attention support, things like that. So our next one is communication errors. So please be cautious when you do the reply to all, right? Be cautious with your emails, because sometimes those emails become educational records. And if an email becomes an educational record, then the family has access to all of those emails. So I tell schools, and parents get frustrated with school people, and school people get frustrated with parents. It just happens. And so the same goes true for a parent or a school individual. If you feel like you need to air your frustrations, I would not do that in the context of an email. I would think about it, and if you need to have some sort of catharsis, write it down on a piece of paper and throw it away. That's not, email could be problematic. Replying to all could be problematic. Rushing to reply, your knee-jerk reaction. Another email problem is using email as a substitute for either a prior written notice or an IEP invitation. It does not. It does, when the state comes in and investigates the district and says, show me your IEP invitation, and you show them the email where the parent said, yeah, I'll be there. Thanks for setting up the IEP meeting. ODE says that's not enough, that you have to have a specific invitation. And then ignoring or overreacting to people who are emailing you frequently. So if you have a parent who maybe it's causing you some frustration and they're emailing you, or members of the team 10 times a day, 15 times a day. That is something that would be disruptive to your day. However, you cannot ignore that. So make sure that somebody is at least looking at the messages to make sure that if there's a response that is required, then the response is given, and it's given in an appropriate way. I think there's oftentimes people get painted of, oh yeah, there they go again, whether it's a teacher or a parent, there they go again. And then it's just, there's the tendency to ignore it. That is not a good idea. All right. Next one is effective IEP meetings. So, I'm sure you've been in an IEP meeting where you've wanted to kick somebody under the table. And if that somebody is a member of your team, whether you're the parents team or the school team, think about, the personalities going into the IEP team meeting, and stress that there is an expectation of professionalism. And so I would communicate that expectations. Professionalism also includes being respectful of people's time. So notifying participants of the starting and ending time of your meeting. You signed up for this presentation today. You knew when it started. We started on time. When it's about going to end, because we listed the beginning and ending times. But so many IEP invitations just are, we're going to have a meeting at 1 o'clock. Well, the parent might think, 1 o'clock, all right, this is the most important meeting for me this whole year. We're going to start at 1, and about 5:30, the pizza is going to come, because I'm going to treat the whole team to pizza, because we're going to be here for a while. Now, that's probably not what the school team thinks. But when it's not apparent from the invitation, and you walk in and say, okay, we've got 45 minutes for this meeting, and the parent says, yeah, but I was having pizza delivered in 4 hours, that starts it off with a problem, and it doesn't demonstrate respect for everybody's time. So professionalism would include time. Professionalism also includes involving the parents in the conversation, acknowledging them. I've had so many IEP meetings where I'm there as the district's legal counsel, and I'm the one explaining things to the parent. That should not happen. If you're using acronyms, or you're using abbreviations, or some sort of terminology that most parents wouldn't have visibility on, make sure they understand. If there's a side conversation going on where the person who's scribing the IEP is talking to the speech therapist, and they're typing away in the document, make sure the parent knows what's happening. Making sure that you come to the IEP team with information in easy digestible chunks. So summaries or charts or other visual aids, that's all really helpful, and it can increase the involvement of all of the participants and show that this is a professional meeting. All right, on our next slide is failing to include, there it is, failing to include non-special ed administrators. So building principals, to making sure that those folks are included in training, they're fully informed about and following the required special education procedures. So not only do they need training on legal compliance, and this is why we've put this series together, people who are merging into the field of special ed, we're talking about legal compliance, but also, how to find resources, like what information is out there so you can do your job, and reference materials. So, there's information out there on how to, collect data, how to document, how to develop IEPs. What resources are there to evaluate educational methodologies? Sometimes educators need better communication skills. When they're sitting at the meeting and there's some sort of conflict, they understand how to resolve conflict. So not just training on legal compliance, your people, maybe those people who might want to kick under the table, that may need some additional training in order to facilitate meetings or participate in a meaningful way. In addition to the district resources and support, your folks should know what's in your board policy, right? What they should know about the law. They should know about guidance from the State Department of Education. There might be handouts, like the handouts from today's materials. There might be online resources, but the board's policy is a key one so that you know what is required. And then, who is allowed to contact board counsel? We get calls all the time. Sometimes it's from the special ed director. Sometimes the principal has access to our team to ask questions. But, what is the process in your district? Does it need to go through the central office when you're contacting the SST for support, or, others for support? So that kind of information needs to go to those who are not every day dealing with special ed. All right. Our next topic is going to be, and it's kind of a good segue, is where can you get support for conflict? So when you need a lawyer or somebody else in a special ed matter, most of the time things aren't good. Nobody is calling me to go to IEP meetings where everybody is happy with each other. Nobody wants me to go to, wants to pay the money for a lawyer where everybody's in agreement. So when you're calling the lawyer, things have probably gotten to a very bad place. And so, you're calling because there's a conflict, you need help to fix it. And those situations can be uncomfortable, and you want somebody who can make things better. So, my perception is special educators seem to be just in their hard wiring. There's some genetic, trait where they want to avoid conflict. And when they have to deal with it, it can be painful. So know where you can, and people like me, I didn't get into the law because I am genetically wired to avoid conflict. All I do is conflict. So if you need somebody who has that genetic makeup, there are a lot of options for legal support. In some counties, the county prosecutor provides legal services to schools. Not a ton, because the education law is highly specialized. Some school districts, they have in-house counsel where there is somebody who is always there. They're at the central office and they assist with special ed matters. Some, like the 30 folks on my team, are attorneys that are in private practice. There are some access to legal counsel through association. So our office does some association work, but some associations also, like the Ohio School Boards Association, has a team of lawyers that are there. Now, they cannot provide legal advice to school districts, but they might be able to point you in the right direction of where you can get more information. And then sometimes your insurance company will appoint a lawyer to defend the school district. And that is something that you should check out to determine what is the scope of your coverage. Contacting your insurance carrier would be a good step, just to know, okay, if I get a complaint, an OCR complaint, is that something that is covered? Would the insurance company appoint a lawyer to help us defend that? Or is it just, is it due process hearings or state complaints, or just any type of litigation? Knowing that in advance is helpful, because sometimes these things move quickly. So if you do have insurance, it's helpful to evaluate the cost of, what that would look like. So sometimes there's a deductible. So let's say it would cost you, the deductible is $10,000, and no matter what, you're going to have to pay $10,000. Sometimes schools make a decision as to whether or not they want to file a claim, because they think it's going to, they would resolve the case for less than $10,000. Their legal fees would be less than $10,000. So why file a claim and then potentially have an impact on the insurance premium? So the other consideration is who is going to be appointed if something moves to insurance counsel. For some carriers, they have really talented special ed lawyers who could be appointed. And so it's really just good to ask. Sometimes it's not. Sometimes it's individuals who maybe have never had a special ed case before. They don't even dabble in it, but they are part of the insurance panel. So it's helpful to know who would be appointed. Sometimes the insurance carrier will cover either part of your own district's legal counsel fees. So sometimes it's not that they're appointing somebody different. Sometimes they will be, let's say maybe they'll pay 50% of the fees, so that you have some benefit out of that. If the special education claims are covered, understand that you may have a specific obligation to notify your insurance carrier as soon as possible. There's usually a notification requirement. You can't then wait maybe until, a month before your hearing to say, oh, you know what, this is getting expensive with my my district's typical counsel, so now I want to invoke the insurance. You may be out of time. So understanding your policy for insurance is helpful. All right, well, I'm moving on to the next slide. Let's say you've looked at all these options for support and you want a lawyer, but you're not quite sure, who. Here are some things that, oops, I'm seeing something different on my screen. Maybe it's, we'll go back. So these are some of the things to think about when you're selecting an attorney. So most of you, I would assume, are not going to buy a house without having it inspected, right? Most of you are not going to buy a car without knowing something about the car, taking it on a test drive. You should also do your due diligence when hiring an attorney. So if you're the one who is responsible for the selection of legal counsel, do your research, ask others in the education community for their recommendations. I would conduct research on the lawyers that you're considering, evaluating their reputation, their experience, their expertise. In my opinion, the most important factor that schools should consider when selecting legal counsel is the experience of the attorney in the substantive area of the law. This is a critical thing in special education. I mentioned we have 30 people on the team. A lot of them are like, heck no, I can't dabble in special education. That's a lot of stuff to learn. So in special education, it is an area in which it is ripe with potential pitfalls. So making sure that you have somebody who is experienced not only in the nuances of special education, but also in the litigation process itself. So, you should inquire about the attorney's background in special education, their reputation, both in the legal community and in the education community. I think, Stephen, I am on a slide that says selecting an attorney. One more, there we go. If the attorney, another thing is to ask about, is the attorney efficient? So if you have somebody who you love them to death, they're like, yeah, I don't do a lot of special ed, but I could learn it. Are they learning that on your dime? Or is the attorney able to answer a question? You might say, okay, well, this attorney is X amount of dollars and this attorney is Y amount of dollars and X is less than Y. The question is, if the Y attorney can answer the question in 15 minutes and the X attorney takes an hour, there's going to be a difference in cost in the other way. So question is the attorney efficient, or does that attorney have a reputation or an experience that would transform a simple legal question into something that is more expensive, or they might make it more complex than it is, or make a dispute acrimonious. You might, on some situations, want an attorney who's like a take no prisoner, pound on the table type of lawyer. This approach may be good in certain situations, but most of the time that approach frustrates the collaborative process that is intended in special ed. And, it could have the potential to drag out conflict, and as a result, drag out your legal fees. I say this often to clients, the only people who really benefit in special ed litigation are the lawyers, because at the end of the day, most people who go through that process are just dissatisfied with it. Dissatisfied, maybe not in the outcome. One person might win, one person might lose, but dissatisfied about how it feels and how time consuming it is and how gut wrenching it is. It's very emotional. So, a lot of times schools benefit from somebody who can get in and get out and have the conflict move on, put behind you, so that you can spend your money and your attention on servicing students and not on conflict. So, ask around, what is the attorney's general school law experience and specific expertise with special ed? Do they have an established education practice? Do they have an established education practice in special ed? Can the school attorney understand and advance the school's interest, or are they, solely focused on litigation. So, you know, as somebody who devotes the majority of my practice to special ed, I find that my job is, you know, really 1/3 legal. You know, what do the law says? What do the cases say about delivering special ed services? How do I defend a school when they're challenged? It's 1/3 about education. You know, what are the scientifically based methods for teaching reading? How do effective RTI systems work? What do the experts say about new methodologies? And then it's 1/3 relational, you know, how to successfully resolve disputes, conduct effective team meetings, communicate difficult information. So if you're involved in the process of selecting a lawyer, I would evaluate all of those things: their technical knowledge, their knowledge about the education community, and their you know, ability to manage the often heightened emotions and relationship issues that are involved when dealing with special ed. And then, you know, and evaluate your intangibles. You know, does the attorney inspire confidence? Do they listen effectively? You know, are there attorneys in the office that you can talk to when your main contact is stuck in a, you know, in a presentation? You know, you know, full disclosure, I just had 3 calls come in. I heard it, you know, here's my phone right here. I had 3 calls come in while I'm giving this presentation. But I also have, you know, 4 or 5 people back in the office who can handle calls if I'm not available. So the question is, are there others on that team who you can talk to if somebody is not able to answer a question? And that, you know, obviously maybe those calls weren't you know, emergencies, but sometimes there are. Sometimes the police are right there, you know, and they want to interview a student with a disability, and you know, you want to know, or the parent is there and you know, there's something happening. So access those or think about those intangibles, and then assess the volume of special education claims. You know, how many, you know, how many cases do you have? You know, maybe you want to spread it out. Maybe you want to have the attorneys in one firm do your special ed work, but your general work is done from an attorney in another firm, you know, or maybe your general work, your, you know, board governance work is done by the county prosecutor, but for specialized matters, you want somebody with a lot of experience. And when you're making all of these decisions, you need to understand the cost. So for private attorneys, their most common fee structure is an hourly rate. But again, as I mentioned, you know, an hourly rate may be different, because if you're being billed based on how many minutes it takes, you also want the most efficient person. So the hourly rate could depend on the attorney's expertise. There's also sometimes options to have flat fee, you know, structures where, you know, you would do all of the kind of advice and counsel for a flat fee. That's sometimes an option for districts. Lawyers generally do bill by an hourly rate. So if you're an hourly rate attorney is somebody that you have, they usually break each hour into smaller increments for billing purposes. So, you know, every 15 minutes, every 6 minutes. And, you know, if you know that your lawyer is billing at 15-minute increments, you can keep track on your end about, you know, phone calls and meetings and things like that. Then, you know, you should pay attention to how much time is spent on your matter. So you would typically get a bill that says this is the amount of time that is spent. You know, attorneys who've dealt with the same problem numerous times in the past, fully understand the law on a given issue, probably can do something in a fraction of the time. But you should be, you know, looking at that. If you only want to have the person, you know, this is a crazy question, it's going to be out of left field. I had a case where a student wanted to bring a robot to school because they had some immunocompromise. And that's not something that comes up a lot, you know, and, you know, they didn't say this, but, you know, that would be something unique. And they say, you know what, I want to see if there's any other cases out there. Don't spend a lot of time on it, maybe an hour or two. You can say that in advance and then come back to me and let me know if there's anything out there. Different attorneys might charge different rates based on their expertise. So somebody who has 20, 30 years of experience might have a different rate than somebody who has 5 years of experience. But ask about that, you know, ask about how your expenses are billed and consider that relationship and that upfront. The other thing that you would be doing is reviewing the agreement. All the attorneys would ask you to sign an engagement agreement, which is the contract that defines the relationship between the attorney and the district. Those attorneys that you work with all are going to have ethical standards. So the school's attorney is going to be the attorney for the Board of Education. They are not going to be your personal attorney. So they have a duty to represent the school district as an entity and not any particular administrator or employee. That would be a conflict of interest. So typically, they would also defend the administrators or employees if they are acting within the scope of their employment. But if somebody kind of goes rogue and is, I don't know, assaulting a kid, right, that would be contrary to the expectations, and it is likely that the school district would not defend. So for example, if you were consulting with your district's legal counsel and are tempted to say something like, okay, you need to keep this confidential and not tell the superintendent of the board, just stop right there. Okay, that's what I typically say. I say, I represent the board, and so there isn't anything that you tell me that is confidential. What you tell me is confidential in the sense that it is attorney-client privileged as an entity. So somebody else outside of the district can't know that, but it is not confidential. All right. Next one is, after you've selected your attorney, you should communicate your expectations for that person. Availability. What's the best time and method to reach you? What is your preferred method of correspondence? Do you like things done in writing or over the phone? Just as a caution, text messaging is so convenient, and that's what we live by, but please don't ask for legal advice. Don't ask me for legal advice. I don't know what your attorney does over text message, because I've got to maintain information about what I say to you. And so for example, you are the special ed director and you are asking me a question about transportation services in your district. And I give you a whole bunch of information and then you leave the district. Okay. And somebody else asks me, what information did you give to such and such school district? Because the next special ed director wants to, have a follow-up conversation. I need to have that text correspondence in your district's file so I can look it up and say, oh, let's look. This file I have here of what I said to, it'll be an electronic file, but what I said to this district, that's not on my text messages, so I have to kind of get those things and put them into the file. So a lot of times if it's, hey, can you be there at this meeting? Or, I have a quick question. If it's substantive legal advice, I typically like to have an email so then you can have that in your district's data management system and not on your personal device. So that's just my rant on text messaging. What is your preferred method of consultation? Do you like to have a face-to-face conference? Do you like people to be there at IEP meetings? Do you prefer somebody to participate by Zoom? Nowadays, there's so many districts that prefer that, not only because it levels the playing field that parents can participate at home. You can get greater participation from people who may have difficulty getting somewhere. If you need a consultant to drive down to, Lawrence County from Athens, you're going to have to build in drive time. But if they can just Zoom into the meeting, there's greater availability, and sometimes it's less costly for folks because you're not paying for travel time. So what is your preferred method of consultation? What is the desired work product? Do you want something in writing, or do you just want to have a conversation? Do you want the attorney to look at your prior written notice and say what's helpful, or do you want them to draft the prior written notice as a starting point for your team? Sometimes it's usually cheaper for the first, you write the prior written notice and we add things that might be necessary. And then communicate your expectations as to who will be doing the work. You might hire somebody who, but most of the work is done by somebody else because that person is cheaper, or that person has greater availability. So just have a conversation about it. Once you've selected your person and you've talked about what you want, then here's some tips on how to effectively use counsel. Make sure there's a lot of communication. I think we're on the next slide. Make sure there's a lot of communication, and know that who is authorized to communicate with legal counsel, who has direct access. Understand, again, the attorney's role. The board's attorney doesn't, represent you, but focusing on prevention should be the role of the attorney. I've said this before, but I can tell you in a much quicker way how to step around the landmines than to put the pieces of your body back together after you've stepped on one, right? It's much easier to say, this is how we can prevent this, or this is how we can guard against or be in the best possible position if there is a conflict, versus, oh, guess what? We've been involved in this conflict for several months. Now we think the lawyer, now we want to call the lawyer, because it's more difficult to unravel. A lot of times you can't put the toothpaste back in the tube. People have stepped in it. Mistakes were made. And those are things that at the end of the day, it becomes difficult to come to a good resolution, because that often involves districts settling cases, writing checks, paying for things that they may not have had to pay for had they prevented and focused on prevention of conflict. So notify your attorney of any threatened or potential legal claims as soon as possible. Prepare, if when you make that call, prepare for that call. Maybe have some information at the ready, because I know if you've ever called me, you will know that I'm going to ask a million questions. What does the prior written notice say? Do you have an assessment of the student's progress? What is the ETR? I want to know enough about it so that I can kind of, in my brain start thinking about, okay, strengths, weaknesses, liabilities. Are there any procedural errors here? Things like that. And there might be things that you can fix at that point. Sometimes the special ed director will say, I just got a call I just got this due process complaint. It's been sitting on the superintendent's desk for a week. And then it took a few more days for me to get to me through interdistrict mail. Sometimes the delay has eliminated your ability to do certain things. So a lot of these, and I'll talk about this after our break, when we get into specific strategies, but timeliness is really critical. Many timelines begin to run on the date when those, a complaint is received by the school district. So, or when consent is received by the school district. So consider, is there somebody at your district office to make sure that things get to the right people at the right time? So when you're preparing for the call to the attorney, know what facts are relevant, collect and review the pertinent documents. If mistakes were made, don't be shy about disclosing those. Notify your attorney as soon as possible. Hold nothing back. Don't be afraid to admit what has happened or ask questions or think you should already know. There's nothing worse than being in a middle of litigation and then having your client tell you an important fact that wasn't disclosed earlier and may have impacted on the case and the entire strategy. Ask critical questions. You should be asking, did we implement correctly? Was the IEP implemented? Was the behavior plan implemented? If not, let's fix it. Did we follow our procedures? If not, can we fix that? Is the student making progress? And how do we know? What data supports that? How could we prove that? Who are the key players in this? And then are there any relationships? Is this conflict really about something that happened 5 years ago when the parents' brother wasn't hired as the transportation supervisor? There may be more going on here. Develop a history, identify, do you have specific questions for the lawyer? And then be prepared to explain, like, what do you really want to get out of this? What result are you seeking? Is this something that you're concerned about, a bigger issue beyond this particular student? Are there political or community issues or internal dynamics or employment issues that might affect the matter? And let us know. You might say to the school district, what, this isn't our strongest intervention specialist. I'm really concerned about that there may not be data. And so that's your preparing. And then when you're having that call, just listen, make sure you listen and understand the advice that you're given. And if you don't understand it, say that. I mean, I am not always crystal clear. I am sometimes, I do this all day, every day, and sometimes I need to slow down and explain myself. That's what you're paying for. Don't be afraid to ask for that. And then also, I know that not every school follows the advice provided by the attorney. I mean, I'm a parent. My kid doesn't listen to me all the time. And that's, I just have to know that. So it's kind of like an independent evaluation. You should consider it. You should make sure that you understand it. But at the end of the day, it's the district's choice. They don't have to follow it. And then ultimately, if the attorney says, if you should tell the attorney that I need this by a certain date, that is really helpful, because just newsflash, most of the time, most of the school districts are having crises at the same time. And so it's helpful for us on the receiving end of all of the, oh my gosh, it's IEP season. Oh my gosh, we got to get all these things prepared, or we need to have an IEP meeting before spring break. I mean, this is a hot and heavy time of year. And if your timeline is, I need this by Thursday, and somebody else's timeline is, I need this by Friday, we're going to prioritize. So make sure that you identify your timeline. All right. Issue assessment. Oh, I forgot about the gatekeeper. Is there one person who's going to control and coordinate communication and keep a copy of all of the written correspondence? Remember, not on people's cell phones and their text messages, so that if that person gets hit by a bus tomorrow, not that I wish that on anybody, but if that person has medical leave or something like that, that we know that that person has the correspondence and it's accessible with from legal counsel. And then your attorney is going to help you assess the issues in dispute. Your attorney is going to help synthesize the information and determine what are the risks and the potential rewards of taking a particular position or proceeding with a proposed cause of action. What are the potential costs, both short-term costs, long-term costs? What are the interests of the parties? What are the strengths and weaknesses? I mean, can you prove that the child made progress? Is there some sort of legal precedent out there that is going to make us more vulnerable or less vulnerable? What other issues might be raised during the legal challenge? What options are there available to resolve the conflict? Is resolution even possible? I mean, sometimes it's not possible to resolve the conflict because it takes two to want to participate in that. So it might be that something goes to litigation just because that's the position of the parent or the school. All right. Next section is this section I call help me help you, right? These are things that you can do to streamline the process and help your attorney. Number one, provide and organize records. I'm happy to dig into 10 boxes of student records, a Google Drive download or whatever, and try to figure out the details of a student's entire educational experience. That's fine, happy to do it. But it would be more efficient and save your district money if you guys organize the records. You guys organize the records. What you can, when you send the documents to your lawyer, make sure that everything is, legible, emphasis on the legible to the extent possible. It's helpful to include, some sort of cover letter that says, okay, this is what I'm sending you. If, putting things in chronological order, great, we can do that. If you have a summary, sometimes I just say, hey, just put the stream of consciousness of what happened when. But make sure that all records are sent to the attorney, and all means all. So all of the relevant records. If you think that it's not relevant, ask your attorney, err on the side of caution. So all of your special ed records, all your meeting invites, the responses, the notes, prior written notices, progress reports, discipline, correspondence, including emails, letters, phone messages, text messages between teachers, between parents and teachers, to and from other service providers, any information provided by the parent. Is there a communication notebook going back and forth between the intervention specialist and the student? I want to see that. Work samples, data from assessments, data collected from your IEP implementation, records from your nurse may be necessary, records from the bus incidents may be necessary. So all of those things would be needed to give the attorney a full picture to be able to assess the legal issues. Now, how do you do that? Could you put all of the IEPs in a folder? Yes. You could put all, everything that comes from the speech therapist, or you could put it, in chronological order. But it's, information needs to know, the attorney also needs to know, is this a personal record? Is this something that is a personal note? And who wrote the note? Sometimes I get handwritten documents. I'm like, I don't know who wrote this. Then scheduling a meeting and assisting with communication between the attorney and staff. Maybe an initial meeting is, okay, we've got to do process complaint. Here's what's going to happen. So everybody has visibility. Something that could help save money, as I mentioned earlier, is if districts create the first draft of documents, making sure that your attorney has access to your school policies. A lot of those are online, both policies and administrative guidelines. Sometimes you need a password to get into those. So, making sure there's access. And it's just also, all of this is just to minimize the amount of time, because time is money, that your attorney has to spend on, non-legal work. And then on the next slide, you should be open to a second opinion, right? A way to help your attorney is to continue to have a spirit of openness. Your attorney can be helpful in providing an impartial review. They could help suggest alternatives and identify solutions. I think we're on the next slide, Stephen. I think maybe. Let's see. There we go. Keep track of the advice provided, including your written correspondence, your notes, and then be open to a postmortem. So after everything is over, after the resolution of the matter, maybe it's good to hold a meeting to discuss, the coulda, shoulda, woulda, right? The lessons learned and the actions for the future. Take a hard look to see what happened and consider, are there things that should be put into place? Training, staff issues, process issues that would prevent or minimize similar conflicts in the future. So, and then finally, make sure that you are keeping up with legal development. So, attending things like this is helpful so that you can have a common language when you're talking to your attorney about conflict. And then at the last thing I want to say is, you don't have to stay with the same attorney for you're not married to that attorney. You are the consumer. If you are not satisfied with some aspect of the legal services provided, speak up and evaluate those legal services. And that's, what you should do as a consumer. All right. We are at, let's see, I think I will keep going just a little bit. So on our next slide is the costs of special education. So this is what happens and why things become so costly. I think that's our next. Here are all the different ways that you may be challenged. So, we're going to cover administrative review, complaints, due process, after the break, but know that there are all these different ways that if somebody is unhappy with your services, they could air their not dirty laundry, but air their grievances. Okay, so there are two types of expenses when you're dealing with these things. It's the cost of the result. So if it goes to a due process complaint, what does it cost to, what does the settlement agreement cost? What is the judgment cost? If the hearing officer says, yeah, this student has to be at a residential treatment facility, there's a cost to that. So that's the cost of the result. And there is the cost of the process, the transactional costs, your legal fees, your administrative fees, the amount of time you may need subs, you may need court reporters, you're going to have to pay the hearing officer. There's the cost of the transaction. And so for many districts, they look at a balancing of costs. When is settling the case the most appropriate thing? Now, and I think I'm on the next slide, when we are looking at the cost, what does it cost? I think one more slide. The defense of a hearing usually involves, the defense of a complaint usually involves that consultation, reviewing of the record. There may be interviews and an investigation, so that people can feel comfortable if they're going to have to take the stand. We'll prepare those witnesses. There may be some legal research. There may be meetings. There's meetings that are required for the resolution process. And then there are documents that are prepared. So briefs and motions and legal documents. And then there is an actual hearing. And if the hearing is 15 days, that's going to be more expensive than if the hearing is 5 days. There are some other costs on the next slide, which is sometimes these are covered by your insurance, transcripts, expert witness fees, hearing officer fees. If the school district does not prevail, so if the parent is the prevailing party, the school district may have to pay for the parent's attorney fees. And then, as I mentioned, the cost of implementing the judgment. So if these things move to an appeal, there's additional costs. And when we think about costs, it's not just on the next slide, not just the money that we see here, but it's the administrative cost. So, preparing for and participating in litigation can really be emotionally draining and time consuming. It can divert a lot of time, money, and resources from other things. So that's both prior to and during the hearing. There's many hours of otherwise productive professional time that is lost. And then there's a cost to relationships. So the majority of special ed disputes are, really emotional. And so you have to consider the relationship between the district and the litigating parent, because the relationship doesn't end once the decision is issued. It only ends when the students graduate from the district, or the parent, all of their siblings graduate from the district, or the parent moves out of the district. So the litigation angst can go on. And so the level of trust and communication, if those things deteriorate, the relationship can be altered for a long time. And then consider the relationship between the district and the community, because some parties might try to litigate their grievances in the court of public opinion. And as I mentioned earlier, support groups and social media may be used to disseminate information, and that can become very polarizing. And then, what are the relationships within the school districts? There have been many situations where schools have lost staff. People are like, I'm tapped out. I'm not doing this anymore because I can't handle this type of stress. And then on the next slide, you have to think about there is some cost associated with stay put, right? So during the pendency of any administrative or judicial proceeding, the student stays put unless there's an agreement otherwise. So there may be a cost there. Maybe it's a student who's in a private placement. And then I often get the question, what does this do? Does this set a precedent? Does this set a precedent in my district? Well, maybe, maybe not, because most things in special ed are individualized. So, if you have a situation where the district has some exposure and there is a concern about the district's liability, that's unique to that particular situation. Maybe student wasn't making progress. Maybe the services weren't delivered consistently. Those are things that are individual. And so that typically doesn't set a precedent, but there are things that are more global that could appear as setting a precedent. So for example, if there is a judgment that says your program for students with autism isn't based on scientific methodologies, that could set a precedent for every other kid who's participating in that particular program. So there are, you can look at precedent in a variety of different ways. And so that would be something that you would want to talk to your legal counsel about before you, consider which dispute resolution process is going to be in effect. So I think this is where we will stop, and we will, when we pick up after our 15-minute break, so we will come back at 10:30, maybe 10:28. When we come back, we're going to talk about how to detect the early warning signs of conflict, and we're going to be talking about how to resolve conflict. And we will do that through looking at the various methods. So we'll come back at 10:29 for those who are specific, and we will see you then. All right, we're back. We got some questions. Okay. First, there's a question here. Can an intervention specialist complete a record review for an ETR while the school psych is on leave? I want to prevent conflict, but my situation is tricky. Lack of provider coverage. This sounds like a specific question about something that you should talk to your legal counsel about, to be honest with you, because it's probably going to depend on a lot of facts. So just as a general matter, timelines for when things are due, like ETR timelines, IEP annual review timelines, don't stop when providers are on leave. So that is something that you're going to have to think about in terms of managing your risks, because like IEPs expire, it's like milk. You can't drink them. I mean, you could drink it, but you're going to get dinged in the form of being really violently ill if you drank your expired milk. But you'll get dinged from the State Department from a compliance issue. So for the person who asked the question, I would consult with your district's legal counsel, because some of the facts may give you some flexibility as to whether or not there might be a waiver of a reevaluation. There might be the opportunity to like do a record review that wouldn't require the participation of the psychologist. But again, that would be very fact specific. All right. So we're going to get into now, and please ask questions, like here, ask questions. Thank you for the question. We're going to talk about, what I said earlier, I talked about, things that are likely to create conflict, how to access support. And if that support is from, excuse me, nose is running, if that support is from a lawyer, how to do that efficiently, cost effectively. And then now I want, and then, what are the costs? We ended with what are the costs of this kind of conflict. Now what we're going to get into is how do you maximize your outcomes by minimizing your exposure and prevent your conflict. So this is, in a perfect world, if you had a magic wand, I think I'm on the next slide. How do you prevent conflict? So first thing is education. So prevention really does begin at what we're doing today, ensuring that special ed personnel and administrators understand, what we've put into this entire series, all of the laws, all of the procedures, the resources in administering your obligations under special education. So that's first of all, you should know what you're required to do. Sometimes easier said than done, right? But the second thing is you have to be sensitive and alert to the early warning signs of conflict. You have to be, your antenna needs to go up when any one of these things happen. So there might be a change in the way that people are communicating with you. So the mode, the tone, the frequency of communication, those typically can be an early warning sign. So, you might see some written requests like, please explain what just happened. More requests for IEP team meetings. So that's frequency. Increased visits to the school or communication with school personnel. There might be phone calls where there's a follow-up with written correspondence. There's, for those of you that are familiar, there's a parent advocacy person in the South that writes a book about, called From Emotions to Advocacy. And anyway, they give the play-by-play of what you should do. Well, I've read that book. So when I see the play-by-play come across the desk, I'm like, you're in trouble. Like there's something's going to be happening. There's probably going to be somebody filing a complaint. Another early warning sign is if somebody has to record meetings, that makes people very nervous. If somebody's asking for copies of all of my child's educational records, and we talked about those educational records are, everywhere. If the parent can ask for that verbally in writing, you may want to respond in writing to document that. But, the reason that people ask for copies of all of the child's educational records is because most advocates and most attorneys are going to ask for that. So they're going to say, go get a copy of your child's educational records. Here is a release form that you can use. And that's usually because they're consulting with someone. Personnel complaints, including if there's a challenge to a teacher's qualifications or a complaint about somebody not implementing the IEP. Parents obviously don't have the right to choose their child's teachers or other staff who work with a child, but that's an administrative decision under the IDEA. But you should know that when there is a negative relationship between the parent and the service provider, that's typically something that's going to trigger some conflict. Another early warning sign is when they bring an advocate or an attorney at a meeting, or they include them in correspondence. Some clients that I work with, they won't have a meeting unless their district's legal counsel can be present if the parent brings an attorney or an advocate. Now, in the days of Zoom, sometimes that used to be like a gotcha, where somebody would come in, they would not disclose that they were bringing an attorney to the meeting, and the school district's like, wait a minute, we need to schedule a time where our attorney can be present. And by the way, the IEP expires tomorrow and we don't want to be drinking spoiled milk, right? There's an expiration date and we got to get this meeting done. Well, I've had many situations where somebody calls me on the phone and says, parent just walked in with an attorney. Can you guys cover the meeting? And with Zoom, it's a little bit easier. So, that's again, another conversation to be having with your attorney if you ever want that support. Another thing that is an early warning sign of conflict is a request for private anything. Again, as I mentioned earlier, if it looks like, sounds like, seems like a request for private services, private consultation, private placement, private evaluation, that evidences that the parent doesn't have confidence in your program anymore. And then, of course, complaints that are filed, formal or informal complaints. So an administrative review, state complaint, OCR complaint, due process complaint. So one of the things that we try to do is resolve those conflicts at your earliest opportunity. And sometimes resolving that conflict, and what we're going to talk about on the next slide, isn't just in your neck of the woods. You're also going to have to work with superintendents and know, when does a special education dispute need to be brought to the attention of the superintendent? What information is necessary? What information does the superintendent need to understand the nature of the dispute? Because they might be the one who has to go to the mediation. Remember, the district representative on the team has to have the authority to commit district resources. So if there is going to be some sort of big ticket item, know that know what the resources there. Know your board. You might need to keep your board apprised concerning litigation that is filed. So that might be something that you would have to go to a board meeting and be in executive session. Know that there's also other people outside of the district that might be interested, that parents might go to the media. And school districts are very limited in what they can say in response to a student because of student confidentiality laws. So you might need to consult with your lawyer, your superintendent. You might have a media coordinator or a media consultant, and make sure that there's some consultation there before making any statements to the press regarding special ed disputes. Okay, conflict resolution options and strategy. So this is where we're going to get into the nuts and bolts of all of the ways that you can, the options for you to try to resolve conflicts. So on the next slide, the first one that comes up is administrative review. So an administrative complaint is a complaint that is filed with the superintendent, and it's a request for an administrative review. And the process under the law is that the superintendent or the superintendent's designee would need to resolve that dispute within 60. No, I'm sorry, that's not right. I'm sorry, I'm just misspeaking. Okay, first is administrative review. What this slide says is a complaint to ODE. So an administrative review is to your superintendent. And the administrative review is the superintendent then within 20 school days has to make a decision, right? They will make a decision as to what should happen. And maybe the decision is it goes to the IEP team, or maybe the decision is this particular service is going to be provided. But that's an internal review called an administrative review to the superintendent. Okay, your board, that this is under the, and I think Melissa Bondi talked about it during our procedural safeguards section. That is something that's internal to the district. Similarly, there is something called an administrative complaint, which is a complaint to the Ohio Department of Education. That is a process So, and that is different than a due process complaint. So an administrative complaint to ODE is when an Ohio Department of Education investigator will, after 60 days after filing complaint, conduct an investigation, look at the district's response, look at the parents' response, and then issue a decision as to whether or not the district violated some administrative code provision. Now, anybody can file a complaint, not just a parent. So it can be, an aide that was removed from the classroom. They can file a complaint. And the complaint is, once the complaint gets to the Department of Education, they then send a notice to the school district assigning an investigator. And then after that, there is what's called a letter of allegations. And the letter of allegations usually says, these are all the things that the parent has alleged, and these are all the things that we think might, if proven, violate the operating standards. We are inviting you to respond to this and send us all of these documents. And they usually give about a 2-week turnaround. So when the Office for Exceptional Children then, looks at what the parents submitted, sometimes the letter of allegations that you get isn't at all similar to the complaint. So don't make the mistake of responding to the parent's complaint. You might get a copy of that from the parent. Only respond to the letter of allegations, because sometimes if the parent complained about 10 things and the letter of allegation says these are the 2 things that we are going to investigate, that's all you need to respond to, because they might have determined that those other 8 issues aren't within their jurisdiction or outside of the timeline or something else, but that does not require a response. There is a mediation option that is typically offered. Both parties can agree to that. We'll talk about mediation. The department doesn't request that you give a narrative response. They just request documents. But I always recommend that districts provide a narrative. And that narrative can explain the records and the positions of the school district. It might explain things that aren't readily visible in the records. And so, as the Department of Education takes the information that is provided, so the records and the narrative, and they can conduct their own investigation, meaning they can come on site and interview people either by person or over the phone. And if that happens, you should be preparing your staff or having your legal counsel prepare staff. Don't leave it up to chance. And then after everything is over, there will be a letter of findings. After they've conducted the investigation, they will issue written findings that will restate the alleged issues. It will summarize the facts provided that they found based on the information provided by both parties, and draw a conclusion as to whether or not the district is in compliance with the applicable standards. And that letter of findings will also outline the corrective action required by the district. So once if you are found in corrective action, then they will likely monitor. So they will require you to provide information about what you're doing to correct those things. Now, one of the things that I usually do is if the district flat out didn't do something or had a misstep, my suggestion is to typically just tell them that we see that a prior written notice wasn't written, or that this prior written notice wasn't completed. We are going to conduct training at this building level regarding the expectations for prior written notice. Like, offer up your own corrective action, because sometimes what you're willing to do is it makes it easier for ODE to identify corrective action. So I like to always offer self-corrections. Always consider the benefits of mediation. If you need an extension of time in order to provide the records, you may be able to request that. It's not always granted. But if it's some issue like the district's on spring break or somebody's on leave, or that may be a reason for an extension. And just again, as I mentioned earlier, contact your legal counsel and your insurance provider, because there may be support that you can get through both. As I mentioned, the timeline is 60 calendar days that ODE must complete its process, and I would suggest they don't always meet that goal. If there is the spaghetti approach, which is like throwing spaghetti against the wall and seeing what sticks. Sometimes parents take the spaghetti approach where they throw every type of complaint against the wall to see what sticks. So they'll file an ODE complaint, an OCR complaint, an administrative review with the superintendent. They'll do it all at the same time. Please know that the Ohio Department of Education and the US Department of Education, they don't want to be having the same complaint about the same issues at the same time. So they might, if set aside one or the other, so that there isn't competing agencies making a decision. But they usually don't know that the spaghetti has been thrown against the wall. So you, as a school district, might have to inform the Department of Education to say, hey, not sure if you're aware of this, but the parent also filed the same complaint with the US Department of Education, and that is pending. Here is a copy of the complaint. And most of the time, if the OCR or the US Department of Education is proceeding with a complaint investigation, the Ohio Department of Education will say that is being dealt with by another agency and we are not going to investigate at this time or perhaps even at all, but it takes you to tell them about it. ODE complaints are only available for issues that occurred within 1 year prior to the date that the complaint is filed. So you would have to go back and, you know, if this is a 5th grader and the parent is talking about issues that occurred in kindergarten, that's not something that you will need to respond to. Now, what if you don't like what ODE says? There's nothing in the regulations that either prohibit or require the department to establish any type of appeal process, but I will tell you that the Ohio Department of Education, we have had success in talking to the Ohio Department of Education about things that are just contrary to, you know, some sort of legal standard. So, you know, if you are concerned that a complaint letter of allegations, or I'm sorry, letter of findings is just wrong, you know, I would talk to your legal counsel because, you know, there may be some ways to bring that to the attention of ODE because, you know, they don't want to get it wrong. All right, so that is a state complaint. And if you've had any experiences with them or have any questions about that, just don't hesitate to pop that in the chat. We are going to move on to due process complaints, and due process complaints are the bigger process. So due process, this is really something your timelines affect a lot of things. So when the district receives the due process complaint, it is critical that somebody gets notified about it. Your insurance carrier, your legal counsel, your special ed director. If it's sitting on somebody's desk, you may blow some timelines. Unlike the state complaints where people can go back a year, due process complaints, it's 2 years unless there's been some expectation that wasn't fulfilled. Maybe the parent wasn't, the district did something where it didn't provide notice. There are some ways where it could be more than 2 years. So the statute of limitations wouldn't apply if the district misrepresented that it resolved some sort of problem or withheld information that was required to be provided, like prior written notice. So what happens when a due process complaint is filed? Well, there is a notice. So the law requires a party to provide a notice of the complaint to the other party. So the district can file against the parent can file against the district, but there's a notice that's required, and that notice has to have very specific information, which I think might be on the next slide. That specific information has to include information about the, who is the student, their address, the dispute, the resolution that they would propose. And if that notice doesn't contain all of the required elements, either party can challenge the sufficiency of that notice, that it's an insufficient notice, and they can do that within 15 days of the date that they received the complaint. So here's a situation where you've got a very specific timeline. And if you blow that timeline because it's sitting on somebody's desk, you can't challenge the sufficiency of the notice. If you do say this notice is insufficient, it doesn't tell me what it needs to tell me, the hearing officer will come in and issue a decision and say, either supplement the notice or refile a new one, things like that. The other thing that has to happen within a pretty quick timeline is that the party has to answer the complaint. So they have to respond to the complaint, which I think is the next slide. And that is within 10 days of the date that the district received the complaint. So that complaint response is required if the district did not send prior written notice regarding the issues in dispute. And that, that usually is something that you have to, say the same type of elements. The response has to include the same type of elements as your prior written notice. So why did the district propose or refuse to take action? What other options were considered? What was the evaluation, procedure, or assessment or record that the district used to make its decision, and then any other factors, so that the complaint response looks a lot like a prior written notice. In addition to responding to the complaint, when a district receives it, it must also inform the parent in writing of free or low-cost legal services that may be available to them. So once the notices have been exchanged, what happens next is called a resolution session, which I think is our next slide. And the resolution session is an opportunity for parents and schools to resolve the complaint before it gets into the litigation process. So this is something that I think is a really great addition to the due process procedures. That resolution meeting has to be held within 15 days. Again, here's another timeline, 15 days of receiving the notice of the parent's complaint. Okay. If the district files the complaint, there's no requirement for a resolution meeting. Who comes to the resolution meeting? It's going to be the parent and then relevant members of the IEP team who have specific knowledge of the facts that are identified in the complaint, including whoever is going to be identified as the district representative who has the authority to make an agreement on behalf of the district. So that those participants need to actually participate. I have had situations where parents will come in and they will just you say, we know we have to be here, but we're not saying anything. Well, that's really not participating. The resolution meeting exists so that people can actually try to resolve the complaint. You can waive the resolution session. However, both parties must agree to waiver. So, and if both parties don't agree to waive it, then that resolution session is mandatory. And if it isn't held, then if the parent doesn't participate, the parent may not be able to have a due process hearing. So that resolution period is when you're having your resolution meeting. That resolution period is 30 days. You can extend that period. You can shorten it up because the parties believe that's not necessary, or you can continue, you can extend it. And when the parties are agreeing in writing to maybe go to mediation. So we're still in our due process procedure. So you've gone through the resolution period and maybe the case is not resolved. Then what happens next, which I think is on the next slide, is the timeline for your decision is 45 days. So the hearing officer will be required to have a hearing and issue a decision within 45 days. Now, newsflash, that usually doesn't happen. Usually there are extensions, but there are no extensions when it's called an expedited hearing, which has to be done within 30 days. And that happens when there's some dispute about discipline or some dispute about a manifestation review. So everything I've talked about is just the general run-of-the-mill disputes. But when it is about discipline or the student's disciplinary removal, those hearings are expedited and all of the timelines that I've talked about are shortened. And so I would encourage you, if you do have an expedited hearing, to look at the written materials that I've provided to you so that you know how quick things happen, and to enlist your support as soon as possible. All right. As I think on the next slide is what happens if you don't have the resolution meeting. If you don't have the resolution meeting, the hearing officer might either delay or deny the hearing. So the district just has to make sure that it makes reasonable and documented efforts to ensure that the parent does participate. And if they just don't show up, they don't respond, whatever, or they say we're not coming, then the district can request that the hearing officer dismiss that complaint. So again, really a strong emphasis on trying to have these issues be resolved. If the issue is resolved, and I think this is our next slide, then you would typically have some sort of written agreement. And so the written agreement is signed by both parties, and you would come to some sort of understanding of the terms. You can do that. Sometimes if one of the things I forgot to mention in participants is if the parent doesn't bring legal counsel to the resolution meeting, the district can't bring its legal counsel. So in a situation where it's a parent who's representing themselves, and you're like, well, how do we get to an agreement if our attorney can't be there? We want somebody to draft something that's legally binding. Well, you can have like a template of, these are the things that are we say, and these are the things that, the rights and responsibilities, but then the what is filled in at the meeting. Like, we're going to provide compensatory education, or we're going to, provide the student with free access to our summer supports, and you put that stuff in. So that might be something that you work with your legal counsel before or after the resolution meeting. All right, then if there isn't a written agreement, now we're moving towards our due process hearing. And that due process hearing is going to be limited to the subjects that were in the due process complaint. So let's say that the subject in the complaint was speech therapy and reading intervention. Then you get to the hearing and the parent wants to talk about extended school year services and raise a complaint about that. And you're like, that was never disclosed. And so the issues that are raised in the hearing might be limited in that sense, because they're not allowed to bring up new issues. Because think about it, if you bring up new issues at the hearing, we haven't had an opportunity to respond. We haven't had an opportunity to go to a resolution meeting on those issues. There hasn't been any dialogue back and forth. All right, so now we're getting into the hearing process, and what happens 5 days, at least 5 business days before the hearing. This is on our next slide. Both parties must disclose all of the information, all of the evaluations and recommendations based on those evaluations that they intend to use for the hearing. There also needs to be a disclosure of who, the witnesses that are happening. And so usually it's like you give this huge binder of documents to the other side, and you only have 5 business days to review that stuff. It's not a lot of time to prepare. So who bears the burden of proof? Well, if somebody says, it was wrong that I should have had extended school year services for my child, the person who's saying that, which is typically the parent, bears the burden of proving that extended school year services were necessary. If the school district files the due process action to seek a change of placement, then the school district would bear the burden of proving that that change of placement is necessary. And so that's how the hearing officer looks at the evidence. Like, has anybody met their burden of proof? At the end of this process, a written decision is issued. Usually that written decision is based on looking at a transcript of the hearing. I mean, it's a very formal process. You have people making opening and closing statements. You have a court reporter there taking down the information. You have people cross-examining witnesses. And then people write up briefs and decision and motions, and then the hearing officer issues a decision. And the decision, if anybody disagrees with it, can be appealed to what's called a state level review officer. And then further in Ohio can be appealed to court. And so what happens while this stuff is happening is called stay put. And I think that's our next slide, which is students will stay put in their current placement. So let's say if the district said, I would like to change the student's placement back to the school district and not the private facility, while all of this stuff is being litigated, the student stays put. All right. Attorney fees. I mentioned this earlier. Attorney fees may be recoverable if the district can show that its attorney fees are necessary because the complaint was filed for, it was frivolous, unreasonable, or without foundation, or for any improper purpose, or the parents can recover their attorney fees if they prevail. All right, I think next one is stay put, which I've already covered. Oh, no, that's the opposite way. Yep, and one more. All right, so here's some dispute resolution options that isn't going to hearing. Facilitated IEP meetings. This is an option I think is terrific. Terrific if you have a good facilitator, of course. This can be requested at any time. Both parties have to agree to IEP facilitation, and the The Office for Exceptional Children will provide a trained facilitator at no cost. That facilitator promotes communication between the team, does not make any decision, but is there to help just facilitate the process. Sometimes those facilitators are actually working through and saying, okay, now we're going to talk about present levels. Now we're going to talk about goals. Or they have the school folks do that, and then they facilitate dialogue and conflict conversations. On our next slide is mediation. Now, mediation can be something that is used both in the context of a complaint, like an ODE complaint, and then you have an option for mediation. It can be used as an option when there's been a due process complaint filed, and it can be used any old time you want to, which is called a direct request for mediation. And both the parent and the school, just like facilitated IEPs, have to agree to mediation. And the Office for Exceptional Children will provide a trained mediator. And spoiler alert, the mediators are the same people as the IEP team facilitators. So you will see the same cast of characters in all of the mediations. Now, recently, it used to be that the Ohio Department of Education had a group of mediators in Ohio. Some of them would go travel certain areas. Some of them would only be restricted to, would go the statewide. But, post-COVID, the Department of Education has changed the way that it is staffing the mediation. So it's not just people in Ohio. And that may be something for you to think about, because in Ohio, there is no specific qualification or certification required to be a mediator. And many people who are doing this work were individuals who did have mediation experience, but also had some experience as an educator, and so I helped the Department of Education on 2 occasions screen mediators, and they did require them to have a certain level of experience, but there's no certification required. In other states, and I actually have a certification as a mediator, and because I do mediations for higher ed institutions and for K-12 institutions outside of Ohio and in Ohio, in any event. So this is why I know that there are different standards. So now that ODE has opened up mediations for people from different states, some of those individuals have had different types of training, and that with the state in which they practice may require something very different than what you may be used to in the mediations that have occurred up until the last 12 months. And I've experienced this a little bit as counsel to a school district. I was participating in a mediation, and there was a mediator who was somebody new to me. I don't think they came from out of state, but anyway, they were new to me. And my job in mediation is usually to try to focus on, let's look at moving forward. Let's look at what has the people brought to the table to see how can we advance our relationship. But this mediator really wanted to have everybody articulate their positions in front of each other. And my concern for that was, you're going to get people getting they're going to get a little irritated by that. We're in mediation. There's already a dispute. We already know that there's a dispute. So for us to articulate our positions again, we've had IEP team meetings. We've talked about the disagreements in the prior written notice. Having everybody sit across the table and say why we think a certain thing may get us in a more adversarial posture than is necessary, because I knew that the district was probably going to agree to some things. And if we got very positional at the very beginning of the process, that might have destroyed the process. So that is a long way of saying ODE has new mediators, and you should be very candid in your assessment of this new mediation system. They have not only changed where they're getting their mediators from, but also how they compensate them. And for better or for worse, those decisions have affected some mediators' willingness to continue to do the work in Ohio, because before it would be they were charging an hourly rate. So if a mediation took 6 hours, they would get paid for their time being the mediator. Now they only pay them a flat fee. And so if the mediation takes 6 hours or 60 minutes, they're getting paid the same amount. And for some, that is not the way that they want to continue to structure their business. So it is the way that this is has shifted in the past year has made a dramatic difference in who is applying for these positions, who is being selected for these positions. And for those who are doing this out of state, they're usually saying, I'm only going to do a mediation by Zoom, right? Or by, electronically. So for some districts that actually want somebody there with boots on the ground, now it's a smaller subset of people who are actually do that. So I've just given you a lot of verbal diarrhea on mediation, but you should know that if you've done it before, it might be very different now. Maybe it's better, maybe it's worse, but it's just going to be different. All right. Mediation is voluntary, meaning that parties have to agree to it and they have to agree to continue to do it. So if as part of the process, somebody gets upset about the mediation and they say, I'm done with this, then it's over. Okay. Mediation can't be used as a step. Like you can't say, oh, well, we'll give you a due process hearing after you participate in mediation. No, it's completely voluntary. And it's not something that the district can strong arm. If the parties are able to reach an agreement, then you would want, just like we talked about in resolution meeting, you would want to have a legally binding agreement that everybody looks at the terms, they sign off on it, and everybody understands the expectations moving forward. In addition, you should know that mediation is confidential. It's a confidential process. And so mediation can't, anything that's said in mediation can't be used as evidence in a subsequent due process hearing or any type of civil proceeding. And there's no, there's actual prohibition on any type of recording of the mediation. So some pointers as you get, if you're doing mediation, make sure that you have carefully evaluated your strengths and weaknesses so you understand. As you're going through mediation, make sure you try to get agreement on in writing on each issue as you proceed through your list. Determine on your own which issues are negotiable and which are deal breakers. Even if the school is willing to address all the legal issues, the case may not resolve if the parents aren't willing to give up their deal breaker, right? In those situations, you have to determine if you're going to focus your energy on the deal breaker or make, some other options available. Invite decision makers to the mediation. Like there should be somebody there who can say, yes, we will do this. And then also remember the difference between mediation and litigation. This is not an adversarial process. Proving your point or stating your positions is usually not necessary because the mediator doesn't decide anything. You can put all your arguments on the table, but then everybody's going to get positional and be upset. Other thing is mediations do take a long time. Like I said 6 hours and I'm kind of like, well, that might be short. Like honestly, a 6-hour mediation might be very quick. I've had them be 10 hours. Sometimes it takes a long time. Sometimes it takes a long time because people don't listen to each other. And that's a key thing in mediation. Another key thing in mediation is that you have an ability to caucus. These things might be on the next slide, I'm not sure. You have the ability to caucus with your lawyer and you can have private conversations. Oh yeah, one more. Those private conversations. Okay, that's another thing. Those private conversations, I'll get to administrative review. I already talked about it. Those private conversations, are good because then we can do some reality testing. You could bounce ideas off each other's. So, that's an option for you to speak privately with a mediator or with your counsel. And then you got to be prepared for the emotions. There is a lot of people come to mediation with a whole host of emotions. Some people are angry, some people are scared, some people are like frustrated and overwhelmed. And sometimes there are emotional outbursts during mediation. If you see that happening, make sure that you take a break. Just as an aside, I was asked to do a national conference on mediation, on special ed mediation for the National School Lawyers conference. And so my theme was everything I learned about mediation, I learned in kindergarten. And one of the points was, you know, people can throw tantrums, and sometimes people need snacks, and sometimes people need hugs, just like kindergartners. And that is very true in mediation. At the end of the process, you know, you've got an agreement, and you have to consider, okay, does this agreement require some sort of action by the IEP team? If you don't, you just want it to be an IEP amendment, make sure the agreement says, hey, and we don't have to convene a meeting to make this amendment. And then if you are agreeing to something, make sure there's a full waiver, right? You shouldn't be agreeing to all kinds of things and then have the parent then turn around and file a different kind of complaint again about the same issues. So they have to be waiving all of the issues. All right, this is the administrative review that I talked about before, which is the superintendent conducting a review and notifying the parties of their decision within 20 school days. So the administrative review is that internal dispute resolution process that is available for any kind of dispute, any kind of special education dispute. So for example, if you have an IEP team meeting and the IEP team doesn't think that the student requires an aid, for example, what would happen is, you know, you go through your process, the district issues a prior written notice saying that, no, we don't believe that the student requires the provision of a one-on-one aid. And you remember that you typically would have the student having a, you know, the parents' rights booklet. And in the parents' rights booklet, it says, okay, you can have an administrative review. So if the parent chooses this option, the parent can then say to the superintendent or designee, I don't like the decision made by the IEP team. And the superintendent or their designee can come back and say, okay, let me hear from you, let me hear from the district. And it's not as if the superintendent overrides, but they could override, or, you know, they could say, yes, the student will do a trial of an aid, or yeah, the student will, let's go back to the IEP team because you've given it some new information, or they can say, let's do an evaluation of the student's behavioral needs. There could be all kinds of things that come out of the administrative review. And the superintendent would then notify the parties in writing, and they have 20 school days to do that. So know that that's an option. It's a lower cost, lower, there's not a lot to it. It's not something that is often requested, but it is there as an available resource. All right, other dispute resolution options that you should think about include, you know, everything that, you know, you do at an IEP meeting. That's a dispute resolution option. A dispute resolution option also could be proposing a private evaluation. Okay, you have this view of the student's reading skills. We have this view of the student's reading skills. You can, let's get an outside person to evaluate. So those are things that are additional options. I think I might have that on the next slide. And maybe I didn't remember everything. Yeah. That's the administrative review. Let's go one more. There we go. Other things that you can do. Your IEP team meeting should be the avenue to resolve disputes. And then there may be some, you know, ways to resolve disputes by just becoming a little bit more educated on these things. And so some resources, I think, on our next slide of where can you keep up with changes, and you know, resources for, you know, further education, employment, and independent living, right? Further education in your special ed, you know, toolbox. So I think maybe one more slide, Stephen. There we go. So, you know, your updates from the Department of Education, updates from your state support team. ODE has kind of e-alerts that they send out. You can sign up for those. You can get special ed updates. You can follow our office. I mean, I post special ed updates through my Twitter feed. We have an ed law, you know, we have a Bricker ed law Twitter, but Special Ed Connection is a great resource. That's they're from LRP Publications. That's where I did my national conference. And they're actually also having a national institute in April in New Orleans. So if anybody wants to go there, I'll be there talking about my topics, the new DSM and one-on-one aids. But, you know, so that's a way to connect nationally with people who are doing this a similar job. The Counselor for Exceptional Children is also a great resource. Your affinity groups, OAPSA, things like that are also great resources. And then, you know, parents, there are many resources for parents, including the Rights Law, COPA. There are a lot of different resources out there, and some of those are in your materials. So, you know, getting additional information always helps you be more astute to and alert to potential conflicts that could happen. All right, now I see there were some questions maybe in the chat. Okay, or it's actually people inquiring about the ESELA. Let's see. I don't think there's anything else. All right. So to end, which is something that I've done in a couple of other of our sessions, is ending with some poetry. So this is my nod to Shel Silverstein. And if you are familiar with Shel Silverstein poems, one is a very famous one. It's called I Cannot Go to School Today. And so this is I Cannot Go to School Today, the special ed supervisor version. So I cannot go to school today, said school attorney Jill McVeigh. I've got 4 contentious IEPs. And the state is monitoring. Lord, help me, please. My plate is full. My nerves are frayed. And I think I might need my own one-on-one aid. I might also add that to my sorrow, I cannot go to school tomorrow. I have the chills. I'm feeling faint. And that parent filed her 6th complaint. Work on Wednesday. I won't go. I can't handle another mask TRO. Return on Thursday. That won't work. I can't meet with that advocate who drives me berserk. Then there's Friday, and if I'm still ill, you handle that private school tuition bill. Back next week, I can't give you a promise that I won't be hiding at a beach at St. Thomas. You go to the board meeting, attend in my place, update them on their federal court case, explain OCR's finding of disproportionality and the nuances of medical marijuana and THC. Help them navigate that bullying hotline and all of the discipline implications of Title IX. Clarify special ed funding and the importance of RTI. And when the school year ends, I might come back in July. The end. All right, folks, I'm going to give you some time back in your day. Oh, people know this Shel Silverstein poem. Awesome. I'm going to give you some time back in your day. Hopefully you will keep abreast of all of the other offerings that are available through the SST. Also, please provide us some feedback about the ESELA program. We are going to be designing the program for next year. It's going to look a little different just because there's going to be some changes to the operating standards. So we'll be updating the materials. And so if you have some feedback about what you might want to see in the program, or if things, you know, you're like, yes, this worked great for me, so keep on keeping on, that's also important feedback for us to have. And with that, I will turn it over to Stephen to see if there's any final comments.
No, I don't have anything other than thank you, Laura, for your time and your office's time this year with that. We look forward to building this out next year with the new operating standards coming down the pipe. If, like Laura said, we value your feedback. So if you can complete those surveys, that certainly helps us in our planning process. And hopefully sometime by the end of the spring, we'll have some dates on the calendar for next year. So you guys can get those marked off. If you have any questions, please feel free to reach out, contact us. Other than that, wish you the best as we conclude our series this year. Wishing you hopefully a smooth, easy rest of the year, especially as far as this dispute resolution stuff goes for you. But if you need anything, we are here to support you, and we will get you to the right consultant. If it's not myself or Aaron or Greg, we'll make sure we get you to the right person. But thank you for your participation today. This recording will be available on our YouTube channel, which is linked at the bottom of our webpage, probably by the end of next week, if you need to reference back to that. Other than that, thank you. Have a good rest of your Friday and a great weekend.